Any more questions?
So let me just say this real quick. These courts, especially the county circuit courts, I've got a letter of inquiry that we've done all across the nation, probably at least 100 times by now. And it's an administrative process. And basically, I ask 4 or 5 questions that the court assumes. Now, you have to understand how an assumption works. I can assume that a pretty young lady is single until she or if she rebuts that assumption. Okay? So, letter of inquiry. Here we go. Let's dig this out. Here we go. So here's the questions that you need to develop a letterhead. Your letterhead is the most important thing that you can do when you're dealing with Babylon. So mine is Mark of the house and lineage of Doe, American freeman, grantor in original jurisdiction. I am one of the people. So I'm a grantor in original jurisdiction, and I am beneficiary of the resultant trust. Then in the letterhead, part of my letterhead, not only my mailing address, but here's 3 maxims of trust that I put right on the letterhead so that whoever reads this knows where I'm coming from. The first maxim is, everything is trust, and there is nothing that is not trust. Well, Mark, what do you mean by that? Well, even this phone call with you good folk is a trust endeavor. Let's see if we can pick out the elements of the trust, shall we? And this is participatory. I want to hear from you guys. So who's the grantor in this conversation we're having? Who's the grantor?
Your all caps name?
No, absolutely not. I am, Mark is the grantor. I am granting you the trust res, which is information.
Okay.
So the property of the trust is information. The grantor is me. Who's the beneficiary of the information that we're putting forth right now?
People listening.
That's right. All you good folk listening are the beneficiary. You're benefiting from the information. So who's the trustee now? Don't say anything. So what's that?
Can't.
In a manner of speaking, yes. But remember,
I'm the trustee.
Yes, you are, and so am I. We are co-trustees because I have a responsibility to give you accurate information. And like a good Berean, New Testament, look it up, you have a responsibility to go vet that information to make sure it's true.
Ouch.
Yeah.
Yeah, that's deep.
So I just dropped Mark's letter of inquiry that he emailed to me 6 months ago in the comments, so you guys can open it there and save it. Okay.
But don't do that now. Let's talk first. The second maxim of trust is no trust shall fail for want of a trustee. The third maxim of trust, now there's 20 of them. There's actually way more than that. There's 20 main ones. I'm dealing with 3 that are germane to what I'm doing here. The third one is the primary responsibility of the trustee is to protect protect and defend and prosper the trust. So when I send this letter of inquiry to the circuit court administrator, they see right from the letterhead where I'm coming from and what I expect. Okay? So here's the body of the, after you get your letterhead configured, and it has to be something you can know and you can defend and you can articulate. If you think that my letterhead is bogus, do not use it. Create your own. Dear Court Administrator, as one of the grantors in original jurisdiction and beneficiary of the Republic Constitution, I am writing this letter of inquiry to find the proper trustee. This inquiry is including, but not limited to, the spirit of transparency and freedom of information request. With that in mind, please supply the following information. Please reply with a certified and authenticated copy of the Circuit Court's Charter of Authority and Jurisdiction. And I will tell you that after 100 of these letters have gone out across the nation, they don't have one. They're operating on assumption. Literally, these courts are nothing more than a Kool-Aid stand a couple of kids have set up on the sidewalk.
I literally did this, what he's talking about with my case in Kansas. And I got a letter back from the administrator of all the Kansas courts. And he literally said in the letter that they don't have a charter or jurisdiction. And
because they're not operating in original jurisdiction, they're operating as a corporation of Babylon. And if you don't believe me, go to Dun and Bradstreet and look up your local circuit court. It'll come right up. Okay? Second question. Please supply a copy of the errors and omissions, bonds, and insurance that indemnifies me from the circuit court. And we will tell you from experience, that ain't going to happen. But they have to have it. And they have to give it to you when asked for it. And they refuse. Third question, please supply a sworn statement of the circuit court's ability or not to act in personam against the man. They cannot. And we'll get into that here in a minute. Here's one that's fun. The Constitution says that gold and silver are the only thing that will be a legal tender, right? And it describes how many grains of silver, how many grains of gold. It goes into great detail, and that no state shall make anything else money, right? So the next question is, which specie money does the circuit court render judgment? They absolutely will not. In fact, they are precluded by a law in, I believe it's Title 18, from doing so. They cannot give up the game. Okay? And then, interestingly, I went down to the city hall with a buddy of mine. He was doing some architectural stuff. And I went down there, and on the wall, they had a big, huge 6-foot by 6-foot map of the city with all of the different zoning on it, color-coded. I thought, well, that's interesting. I looked over, and right across the street is the circuit court. So I looked on the map and found the lot on the circuit court, and it was zoned in the city. So in other words, the circuit court is not autonomous on that land. It is city jurisdiction land, right? And it's zoned small business. I thought, well, that's interesting. And then I looked over, and here's the next window was for city licenses, business licenses. And there was nobody in line, just some guy sitting there twiddling his thumb. So I walked over and said, hey, you got a second? He goes, absolutely. I said, hey, and I pointed out the window at the circuit court, and I said, can you pull up the circuit court's business license, please? And he looked at me, and he said, that's a good question. Let's find out. So he clickety-clack on his keyboard, clickety-clack, pulled it up, clickety. He goes, it doesn't appear they have one. I said, well, now isn't that curious? Because your zoning says they're zoned small business right there on the wall map. And he goes, yeah. And I said, and every business in the city has to have a business license, right? And he says, yeah. And I said, and you're telling me the circuit court registered with Dun and Bradstreet as a corporation doing business does not have a business license? And he clickety-clack, and he said, that appears to be what I'm telling you. I said, you got a manager in the back there somewhere? He goes, I do. I said, would you ask them why the circuit court doesn't seem to have a business license? And if there is an exemption, please cite the statute that gives them that exemption. He said, I'll be right back. He comes back a few minutes later and says, I got nothing. There doesn't appear to be a specific exemption. They just don't have a business license. I said, isn't that curious? He goes, that is curious. So we're going to ask for it. If an exemption is claimed, state the specific exemption. Then the letter goes on, be advised that silence will be a breach of trust. Non-answer will be a breach of trust. Anything other than the proper response with specificity will be a breach of trust. Thank you for your prompt response. The circuit court has 10 days. Please respond to the address exactly as written above. Now, at first, we didn't get a response on the first letter. It says 10 days. 14 days later, the second letter goes in the mail. And the second letter says, I'm puzzled by the circuit court's lack of response. It would seem that if the circuit court were authentic, it would be eager to reply with the requested items. Perhaps the circuit court is unusually busy, which is understandable. I therefore, in my magnanimous being, give the circuit court an additional 10 days to respond. And then I go through a repeat. The third letter says, it now being the third letter of inquiry, I find my patience wearing thin. One wonders if there might be a conspiracy of silence and indeed the possibility of racketeering afoot. While one shudders to think of that possibility, this may be the only conclusion one could come to. However, because I am magnanimous, I give yet another 10 days for the circuit court to reply. And then the fourth letter is a declaration and decree that the circuit court does not exist according to its own testimony. Now, we've been getting, usually on the second letter, they can see the handwriting on the wall, they recognize the administrative process, and they usually respond with something that says to the effect, we have no responsive records to your request. In other words, we ain't going to tell you. And then, so if you don't need to send letter number 3 because they already responded, then don't send letter number 3, go right to letter number 4, declaration and decree. And we made the local county administrator, circuit court administrator, pissed. She wrote a letter back that said, after we'd done about 12 of these different people in the city, she wrote back, I have responded to this so many times and I'm getting sick and tired of it and blah, blah. And then she realized what she'd done and she went back to her, vanilla flavored responses. But we got under her skin. So let me tell you what the assumptions are that the court make anytime they want to do business with you. These are assumptions that can and need to be rebutted. The first assumption is because they're a corporation, look it up on Dun & Bradstreet, get the D&B number. Okay? Find yourself a friendly notary and have them print off the Dun & Bradstreet report on the court and have them certify it as authentic. Okay? It's a corporation. In order for a corporation to do business with you, there must be a contract. In fact, the Constitution says that the right of contract shall not be infringed upon. I'm paraphrasing. Now, that means the right of contract. What that means is you have the right to contract, but you also have the right to decline contract. So if the court is assuming contract, all you have to do is rebut. I have no contract with the court, any of its subsidiaries, the police department, the city of, the county of, I have no contract. And that should end it, but it won't. So next thing you do is you say, if there is a contract, bring it forth and put it on the record for examination. What does that mean? Well, if you Google elements of contract, you'll immediately come right up. There's either 5 or 6, depending on the response you get from Google, elements of a valid contract. And every one of these elements has to be in place. Clean hands, full disclosure, meeting of the minds, exchange of value, all the things that have to be present for a contract to be valid. Okay? The second thing that the court assumes is that you are an enemy of the state. Title 50, subsection, I don't know, it's been too long, 2742 or something like that. Title 50 is the codification of the Emergency Banking Relief Act, which was modified from the Trading with the Enemy Act back during the First World War. And they changed one word from enemies without the United States to enemies within the United States. Or in other words, your government, this fiat corporation government, declared they are enemies of the people. But as most lawyers do, they word it so it sounds like you're the enemy. So if you say something like, I am neither an enemy nor an ally of an enemy of the state, you just rebutted one of their most powerful assumptions to gain jurisdiction. They also assume that you're surety for a legal fiction. Do you have that doctrine of parity, Kent? Let me see if I can find it here. Oh, I already have it up. Okay. It's in that letter of inquiry. So here's the Supreme Court of the United States back in early 1800s. Here's the quote. Inasmuch as every government is an artificial person, an abstraction, a creature of the mind only, a government can interface only with other artificial persons. The imaginary have neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons and contracts between them. So how do they assume jurisdiction over the tangible if they, an artificial entity, the court, have no parity? How do they do that? Does anybody have any idea? Anybody?
They assume you're a minor.
Well, they do, but they still have to. So you're the tangible, you're the man, you're the flesh and bone. The court is an artificial entity. And the proof of that is every time they summons you or whatever, it's all in all caps, right?
Right.
All caps is an artificial entity. So let's go back. See, in 1933, I think, what's that game? Who published Monopoly? Parker Brothers.
Parker Brothers.
Parker Brothers. Right on the box, it had a picture of Morgan, J.P. Morgan, a characterization of J.P. Morgan, right? Mr. Moneybags. So let's say you're going to play, everybody played Monopoly, right? Everybody's familiar with it?
Yes.
So what they were doing was they were showing you, see, they have to tell you what's going on. Well, they did it through the game Monopoly. So you're at Thanksgiving, dinner's over, all the cousins get around the dining room table and they pull out the Monopoly game. They pull the board out, unfold it, and throw it in the middle of the table. What's the first thing that has to happen before you can play?
Choose an avatar.
Choose an avatar. Give that man a cigar. Top hat, race car, iron, whatever, right?
Right.
Without the avatar, you cannot play the game. So what Babylon did was they set up their fiat fake corporate construct is they had to issue you an avatar. What is that?
All caps name.
Where does that derive from?
Social
What did they
Security
issue?
trust.
Your birth certificate.
Birth certificate. Winner, winner, chicken dinner. So they issued an avatar. Now, the birth certificate is on bond paper. In fact, in the filigree down in the lower edge, usually it says American Bank Note Company, real small. It's a security. It has all of the attributes of a security. It even has a CUSIP number printed in red, somewhere on the front, somewhere on the back, doesn't matter. It's on bond paper. It is a security. And one of the first maxims is everything is trust and there's nothing that's not trust. So here's what happened at the advent of your nativity. Your mama took one look at you and said, oh, my baby boy, he's going to tear it up. I need to get him a game piece so he can play in the game of commerce. So she made application to the state to create that avatar. So when she received the birth certificate, it is a security that evidences the trust that was created by your mom's request. It is a trust. The security has value. It is a security that evidences the trust. Okay? Now, if you go back into scripture, into Proverbs, at least a half a dozen places in various ways, it says, if you're surety for a stranger, you shall surely smart for it. Go look it up. Do not take my word for this stuff. You have to know that you know that you know what this stuff is. So if my trustee says do not, or grantor trustee says right in the trust indenture, don't be surety for a stranger, there are few things stranger than being surety for a legal person. Person, from the Latin. Per, meaning through. Sona, meaning sound or talk. So person is literally a talk through, or what we would call in today's vernacular, a mask. It's an artificial construct. All the world is a stage and we are but players on it. Shakespeare had it nailed. And then they assume that you're surety for all kinds of other things. So would you like me to relay an incident that happened with me personally in our local circuit court?
Yes.
So I had an issue that I had been using to learn what the courts were doing and whatnot for about 20 years. And so they invited me to come back and play. This was about 8 years ago. So I go in and they call the next case, and as I'm walking through the bar, I'm striding in my cowboy boots. And as I'm walking into the bar, I say, may I address the court? Now, the judge had his head down looking at his docket because he can't recognize you walking in, because to him, he can only deal with an artificial person, and you are merely a surety for the game piece, okay? We have to understand what's going on here. Court is nothing more than theater, okay? So he pops his head up, looks at me, and kind of gets a wry smile on his face and says, please, go ahead. He was probably thinking, I've got room in my great bar hotel, and I can't wait to get another surety warehoused. So the first thing I said was, I am neither surety I am neither an enemy nor an ally of an enemy of the state. And neither am I surety for any legal person. Now, I'm being very honorable. I'm using words that the peanut gallery doesn't know what I'm talking about, okay? But the judge does. I said, neither am I surety for any other entity. And about this time, he starts interrupting me. He has lost it jurisdictionally. And he starts asking me questions, and and pontificating and carrying on. And then he says, "Do you understand?" And I swung my head as far over my left shoulder as I could, and then swung all the way across the courtroom to my right shoulder while I'm saying, "I don't understand anything going on here." Because remember, in legalese, which sounds like English but is not, "Do you understand" means, do you stand under my authority? And when I theatrically said, "I don't understand anything going on here," and I ended looking him dead in the eyes, and I watched his countenance physically fall. From then on, it was theater to get me out of there, because he had lost everything. No assumption of jurisdiction, no nothing. It was over for him. Now, like I said, I'd been using this case for 20 years to play with. Immediately, it was dismissed. They didn't tell me this. They did this in the succeeding days. And they made the case itself go completely away, so I don't get to play anymore in his court. Because I was being very honorable to him. I was using his language that he understood, but the peanut gallery did not. So I was not giving up the game, but I also wasn't going to allow him to continue with his assumptions. And it worked beautifully. Here's another thing I used about 10 years ago in that same court. I had just learned a maxim in Bouvier's Law Dictionary, 1865. There's a maxim that says it's impossible to require an impossibility. So I didn't know what I knew now. So they did the whole song and dance, and the assistant DA said, "Well, we need you to pay $300 a month." And I said, "That's impossible. I can't do that." And he looked at me and he said, "Well, then $225 a month." And I said, "That's impossible. I can't do that." And then he said, $50 a month. And I said, "That's impossible. I can't do that." I walked out of that court, no contract, no requirements. It was over. Now, about third hand, I heard of a guy that went completely through a trial, through the verdict, came back a few weeks later for sentencing. And between the time of the trial and sentencing, he learned the maxim of impossibility. So they said, "We've handed down a verdict." Oh, and everything that happens in a courtroom is an offer. You have to accept. According to the Constitution, they can only operate by your consent. Look it up. You have to agree. So they said, "Well, we're going to put you in a county pokey for 2.5 years." He said, "I can't do that. That's impossible." They came back and said, "Well, then we'll do it for 1.5 years." And he said, "I can't do that. That's impossible." They came back and said 6 months. He says, "I can't do that. That's impossible." And the judge ran out of the room. It was over, and he never went to jail. It was over. You have to agree. You have to consent. The best way to do it, however, is to not get your butt in a sling and to do everything through an express trust in divine/common law with documentation from the trust, this private trust, that says you're the trustee and that you're on trustee business utilizing trustee or trust property. You're on trust business utilizing trust property, and all you are is the trustee, and there is no jurisdiction granted when you do that, when you do it properly. Okay? Don't do Babylonian things, Babylonian ways, because they're a death cult. Their job, because they are created by Satan, their job is to steal, kill, and destroy. And we have the full authority. We have been given dominion. It's time we acted like it. And we can literally inhabit the kingdom on earth right here, right now. This is not for the faint of heart. But that God's not looking for the faint of heart. He's looking for warriors. He's looking for men and women with backbone who
And
can
that is-
stand in his kingdom.
And that is what, you know, I've been talking to you guys about, you know, doing all this stuff and getting free, is because this is how you take the kingdom. This is how you step into your birthright. And so I just wanted to interject.
Yes, absolutely. Now, we can talk about later on, at some other time, we can talk about how to implement Weiss's suggestions.
Yes, yes.
Yeah, and we will, once we get through the first few parts of this, where we get everybody where their trusts are written. And
Well,
then,
the first thing I would do is that letter of inquiry.
right.
You want to set the court back on its heels. You want, in a very honorable manner, you want to put the court on notice. We're coming for you.
Right.
Okay?
But should we do that even if we, I mean, say we don't have a court case, should we still do the letter of inquiry?
Absolutely.
Yeah, you don't have to have a court case.
You don't need a court case. In fact, it's better if you don't.
So we do the letter of inquiry and we just file it with the county?
Yeah, you'll find out, go into the website, and I don't deal with judges. I don't even acknowledge their existence. When I'm in court, I talk about the court. Don't make this personal. Be
Yeah, you need
smart about this. Be honorable.
Yeah, you need the administrator. So the judge.
You're looking for the, and we're not talking about the clerk of court. We're talking about the court administrator. And where I live, there's actually a state court administrator.
So
I put
in the comments, I just put that in there. I sent you guys the letter that I got from, it says jurisdiction, and that was from Kansas. So the administrator for the court is John Houston. He's the administrator for the entire state of Kansas. And so every time I send a FOIA request, that's the idiot that responds.
But I send 2 letters. Every step of the way, there's 2 letters. One goes to the local circuit court administrator, and the other one goes to the state court administrator in open CC. I want them to both know they're both getting this letter. Okay? Here's the difference between kingdom and empire. Empire is non-disclosure. They don't tell you any of this stuff. In kingdom, it is full disclosure. We don't do this in a hiding in a corner. We do it out in the open for everyone to see. Okay? And we got back on colored letterhead with blue ink signature replies. Okay? And the reason I want you to do the letter of inquiry is so that you know these courts have no jurisdiction, that they are illegitimate, that they literally stood them up out of nothing. They're paper tigers. They are without substance. You need to see this. You need to hold these letters in your own possession. And if you want, you can do the same thing with the county sheriff. We informed the county sheriff over lunch one day that he was nothing more than the CEO of a corporation. And he said, oh, hell no. And we said, would you like us to prove it? And he said, I'll do it right now. And he got on his phone, and sure enough, it came up, CEO of the sheriff department. Department of what? Department of the corporation. And he was livid. He got up and left. It was over. So now he is without excuse. You can do this with any court, and I would suggest you do so, including I would do it after you get your administrative process completely finished. I would bundle everything up and make a half a dozen copies of it and get certified copies from a notary. And then I would notice the sheriff so that he is without excuse, and ask him the same questions. Okay? Because what we're doing is we're letting them know that we know. And there's no more qualified immunity. In fact, I put it right in the final declaration and decree that you guys have, that there are no qualified immunity and no, the other trick they like to do is mistaken identity. And I tell them right in there, and mistaken identity will not be tolerated. So it takes 20 years and a few times in jail to figure out what these guys are doing, so that I can show you guys what they're doing, so that we can countermand it without you having to go to jail. One more little tidbit, and then we'll let you guys go. Way early in my Patriot journey, I put in some paperwork. Don't even remember what it was. Don't know what it did, if anything. And they brought me into court, but they took me into a courtroom I'd never been in before. And it had, instead of the glare of the fluorescent lighting, it had subdued lighting. And instead of a flag behind the judge with the gold fringe, it was an old, original American flag with no fringe. And I knew enough to pick out these points and go, okay, something's different here. But I didn't know what I know now, and I wasn't able to capitalize on it. But this is real. What that told me is this is real. And when you stand in honor and know who you are and use the correct verbiage and rebut the assumptions and are friendly yet assertive, they accommodate you, because they hide behind trusts themselves, and they're not going to muddy the waters that they hide behind. Okay? And we can talk again, but I want to encourage you, this is real, it's tangible, whereas Babylon is smoke and mirrors and intangible. You just have to know who you are and how to conduct yourself as a child of God. Any other questions?
All right, so we're at the end of this. we're pushing 2 hours, so we have to get moving here. I really appreciate you being here, Mark. And this call was recorded. I'm probably gonna have to split it up into two things, but it's fine. This is a lot of good information. I'm glad you guys got to hear it. This is the guy that is definitely helped me through all of my troubles in the last couple of years. So you guys are really are gifted to be able to hear this guy. And so we'll have another call with him. We'll have more calls with him, so you'll have more opportunities to talk with him and so on. So I thank everybody for coming. I thank everybody for participating, and I hope this tonight's call will help you work through your trusts and dig deeper into the Weiss's trustee handbook. And also, he mentioned Suits and Chancery. If you haven't gotten that, get that book. It's only $50 on Amazon. So, all right.
The other one
yeah, go
is
ahead.
Gilbert's Law Summaries on Trusts.
Yep, that one's good too. I
Okay.
haven't read that one yet.
Well, that's actually the first one you should read. The second one is about the trustees. But the first one lays out trusts. Okay, and so start with Weiss's handbook before you get Suits and Chancery, because it's a major tome. I want to say it's 800 pages.
Yeah, I mean, I haven't gotten through the whole thing. I don't know, I probably listened to 15 videos on YouTube so far on the Suits and Chancery. I haven't even got partway through it.
The interesting thing about the Suits and Chancery is one of the first things it does is it goes through the 20 or so maxims of trust and relates it back to scriptural principles.
Yep.
So literally, the maxims of trust are scripture codified.
Yep.
Okay.
All right. Well, thanks everybody. And I'm in the process of getting these videos on the Dropbox so that you guys can go back and reference them. So I should have that done the next couple of days. So thanks for being here, and thanks, Mark, for taking your time to help educate everybody, and we'll talk to you soon.
Yeah, thank you, Mark.
Thank
You're
you.
welcome. You're welcome, guys.
All right.